Hello and Yali Mudat. My name is Parviz Laka, and today I have the great pleasure of introducing a wonderful young lady whose name is Sheila Ali, and she is an employment barrister. She's been a barrister for 18 years in this realm and has some fantastic insights into both the furlough scheme and redundancies at this time. It is a time of great uncertainty, and so a lot of the members of the Jamat have been asking the Economic Planning Board for answers to these questions. And so the purpose of today's interview is to help answer those questions and perhaps shed some light on what both employers and employees need to do. Now, before I call the great Sheila Ali, I will give you a little bit of an introduction into her history. So Sheila is a partner at Ali & Holm Associates, and she has been involved in many wonderful cases where she has had some very satisfied employers and employees. One of the most famous cases that she's been involved with was the Mackin and BNP Paribas case. And she successfully represented the claimant in what was termed by The Guardian as a rare win. So she's clearly excellent in her field, and this whole case sparked the beginning of the hashtag #MeTooPay movement. So she also has some very interesting things to say about anti-discrimination law during the time of coronavirus as well. She's appeared on BBC Radio 4 and other media outlets including Bloomberg, the Daily Telegraph and the Financial Times in relation to her employment work. So everything that she has to say is very, very valuable. And I'd like to say thank you very much for her time before we begin, because she's taken a great deal of her personal time to talk to me today. And I very much hope that you enjoy her interview and also are able to extract from it the information that you need at this great time of uncertainty. Hi Sheila, how are you? It's nice to meet you.
Yes, it's nice to virtually meet you too. It's lovely to be here with you today.
All a very different setup, I suppose. But essentially, I guess today is about answering a lot of the questions that the Jamat have on employment law, and that end you are our expert. So I guess the place to begin is there's been a lot of changes broadly, I guess, in terms of employment law during this time. So do you want to just highlight some of maybe the issues that have come up during this time that might be of interest that we'll talk about today?
Sure. So obviously a lot of us have to work differently now. So, and I also think it's one of the gifts of this time. Some industries that thought I would never survive with my workforce working from home are now learning that you can work from home. Yep. So I think that's very, very positive for a lot of industries, including the courts. So I speak to employment tribunal because that's my primary field. But for example, they're investing in video technology. And even though some people are a bit apprehensive about it, you know, I've seen people suffering from stress and anxiety that maybe don't love that. However, it's meant the court has been able to keep going, and potentially we can work in a much smarter way going forward, because the laws already existed to say that we can use this and we can work remotely. So I think what it's encouraging for some industries is to work smarter. On the flip side of that, we can't really ignore that there are some industries that think, I can't continue, I need my workforce here, or, you know, my business is just closed for now. And so we've got, I know what we're going to be talking about, we have the option to furlough. If you are a business, you've got the option to get a business interruption loan as well from the government. So, you know, we're lucky in this country because the government has put these measures in place to be able to help you. And perhaps they're not perfect. You know, I've had complaints from all sorts of people going, but it won't cover me, and, you know, I'm suffering. And my heart goes out to all those people. You know, I don't want anyone to be suffering or losing their business right now. But if we compare our situation to, say, some other countries that don't have that sort of support at all, you know, we're trying our best.
Yeah, and I guess let's maybe start at the basics first of all. So the word furlough has come up quite a lot over this period of time. And my understanding is that there are quite a lot of conditions associated with furlough. So maybe would you be able to explain to begin with what furloughing is and who it applies to, maybe?
Right, yes, sure. So furlough is a mechanism where you can lay off your employee. And layoff was the old term for that, and they've called it furlough now. And what that means is you've not got work available for them, so they're being asked to stay at home. Now, prior to this period of time, what would have happened is maybe the employee wouldn't have earned anything during that time. And obviously that is really difficult for people that are paying their mortgage and just having to live. So what the government have decided to do is, if you are a business that is in that state where you're going to have to either lay off or make redundancies, they've said we'll pay 80% of your employee's salary if you furlough them, which encourages businesses to keep those employees on rather than make those redundancies. Now, there's no right to force your employee to go on furlough, and there's no right for the employee to actually insist from your employer that you're giving it.
Okay.
So it's got to be an agreed process. There may be a right to lay off in the contract of employment, in which case that differs. However, this has got to come via agreement. But what I'd say to an employer, and I'm an employer myself, I wouldn't want my employees to suffer. You know, I'd very much want to pay them that 80% while it's available. And at a later date, if I do still need to make those redundancies, I'd make them. But look after them right now. It's a difficult time. For the employees, I'd say, well, you could insist, no, I don't want 80% of my salary. I want to keep coming to work. But your alternative potentially is redundancy if that work just isn't available. So what I'd encourage both sides to do is be sensible about it and come to some sort of agreement. What I'd add to that is, originally when the government brought these measures into place, they thought a furloughed employee should not be able to work elsewhere. You know, you were essentially sitting at home or whatever you're doing and not working. But they relaxed that because I think they became aware that supermarkets need help, hospitals need help, and if you want to go and do something else, so you are allowed to do that.
So technically, you get another job in that time, but that wouldn't affect your ability to be furloughed elsewhere.
Correct. So you can now work, even though that wasn't the government's original intention behind that. Another popular question that I've had is around 0-hour workers, and does this apply to them? If you are on PAYE, then yes, you can ask for it, and the employer can give it to you. And again, that has to come from agreements. So
it is very much at the employer's discretion.
It is.
And in their picking and choosing of how that works, are all employers holding furlough consultations, or are some of them choosing to? And how does that process work in order to get to the agreement?
I think this is a real great unknown.
Okay.
You know, as many things are, because the law has just suddenly changed. You know, usually a change like this would be something that's debated through Parliament, and they'd have thought about it and thought about how it works. So there are very grey, unanswered areas here where, you know, legal opinion's not always going to agree either. But if I was advising an employer at this time and you have to select who goes on furlough and who stays, I'd say the most sensible thing to do is maybe run it like a redundancy consultation. And I know we're going to speak about redundancy as well, but would it be valuable if I tell you how that should work?
That would be great. I think that
okay.
Yes.
All right. So redundancy consultation works like this. You have to tell your employees at a point in time when the redundancy is first contemplated. So if you as a company are thinking, I need to make some people redundant, share that with your employees. And it could just be from a marketing broadcast or a mass broadcast message. But it's important that they know that this is in your head. The next stage of that is then you have to, and it differs whether you're a large employer or a small employer. So what I'm giving you is a real bare bones basic. And if you need some more detailed advice, obviously you can get that. But the second stage of that is then you have to select a pool of people that may be made redundant. Okay, so that pool could be one person. And where it's appropriate for that pool to be one person is if that's the only person doing that job. But even then, be very careful about doing that. I did a redundancy case recently where it was one of my equal pay ones, where there was a female holding a specific job title. I'm going to give it the generic title of director for privacy reasons. In her company, there were 4 individuals that held that same job title that she did. And the employer argued she was the only person doing that specific role. However, because there were 4 individuals that held that job title, and our argument in that case is she could have stepped into any of those roles because they all had similar experience. If you have something like that going on, just be careful about who you're putting in the pool, because it needs to be fair. You can't just single someone out because you don't like them. You know, that's not really how things should work. You know, you have to put some thought into, well, these people will go in this pool because they're in this department. You know, that's something that makes sense. And you can also consider a practice which is called bumping, and bumping means someone else will lose their job, so a particular employee will step into that job. You know, is that possible? Should that person be in the pool? I don't know. I mean, these are questions that you'll have to ask yourself as an employer, but whatever that selection of the pool is, has got to be fair. From there, you've got to do the unenviable task of selecting who could go. And again, that process has to be fair. So the way that you should do it is think about some objective criteria that is used to make that selection. So for example, work performance is a great one. Okay. You know, so, you know, who's performed better? Again, be very careful, because my sort of very big equal pay case, well, that was one of the issues. The work performance reviews will run in a discriminatory way. That was the finding of the tribunal. If you've done that,
has to kind of adhere to anti-discrimination laws as well and be very, very transparent and fair, I'm guessing.
Absolutely. So as long as you have that, then, you know, work performance is a good one to use. I've also seen a number of sick days that people have taken, or, you know, that kind of thing, who's had the most absences, the most lateness. You know, these are all very objective things. But again, with sickness, I'd say be careful, because are you discriminating on the grounds of disability or maternity, you know, or something like that? So whatever you pick, just put some thought into it and make sure that it's objective.
So that's quite so that's kind of in the redundancy element. So that's a kind of redundancy consultation. So how would that then sort of translate into the furlough element? Do you take the same or similar factors into consideration, do you think? Or
I would think so. You know, I think let's be practical about it. Step number 1 in redundancies may be who actually wants to go. In fact, I had a conversation with someone today saying, you know what, I actually want to retire. You know, I'd happily take a redundancy payment. I just want them to talk to me about it. So you will have some employees that are of that mindset, thinking, you know what, I haven't spent time with my kids.
And that's something that they can raise.
Yeah. You know, why don't you ask your employees, are you willing to go? Or are you willing to not? And I mean, hopefully you've done this already, but some of those employees will be a lot more willing than others, in which case I think that's an easy decision. You know, take the people that are willing to go first, and then let's have the selection procedure for the people that, you know, want to have their full 100% salary or want to work. And, you know, as an employer, there's nothing stopping you from topping up that government grant. So I know a few employers have also done that. Okay. Then once you've got your selection criteria, obviously apply that fairly No, hopefully that goes without saying, but there have been problems. And then, applying it fairly means you're not using your subjective self to think, I like that person more than that person. And hopefully that's pretty obvious. And then, so I'd say that that's, adopting a similar process for furlough would be the pragmatic, sensible thing to do. But I don't have any specific guidance on that. Just as an opinion, as a practitioner, that's what I think would be best. Going for the redundancy, there are a few other pieces that follow on from that, which are, once you've made the selection, obviously you have to invite the employee in for a meeting to discuss it. It's a formal it's a formal consultation, and then it's a formal meeting to say we're considering your dismissal. You need to, throughout the process, you need to bear in mind what are their views, because their views could be, I could work part-time with this person. Could you consider that? I don't know, but you might, and you want to look like that you've been a reasonable employee and listen to them. In those final meetings where you are considering dismissal, they've got a right to bring a workplace colleague or a trade union representative with them. And you also need to give them a right to appeal. So if you've decided to make them redundant, give them the right to appeal where they can raise anything that they want to raise. The other piece is there suitable and alternative employment for them? Redundancy at its core means that job or that role didn't exist anymore. And it could be because the business is shut down. It could be that you've been replaced by a computer. But in some form, that role shouldn't be there. It's no good for you to just recruit someone that's going to sit in that person's place, because that's not a redundancy. And we laugh, but some people have done that and say, yeah, I'll make you redundant, and then employ someone else. So I think that is why the suitable alternative employment is in there. It is a subjective choice for the employee to deem whether that's suitable or not. But you have to be, if it's available, you have to be seen to have at least given the opportunity to the employee to go for that if they wish to.
So I guess two things to take away from that are, one, to really consider how your business is structured and any restructuring that can or needs to take place. And I guess the second is to make sure that the employees themselves are aware of all their rights as well.
Yes.
That's what you need to do.
And if you're an employee, I know a lot of employees where I ask for their contract of employment. What does your contract of employment say on redundancy? It's not a mandatory thing to put in a contract of employment, by the way. So if it doesn't say anything, then in general, it's a week per year that you've been employed if you've been employed over 2 years. However, most people haven't read their contract of employment.
Yeah.
There's also an employee handbook. So if your contract of employment doesn't say very much, have a look at that handbook, because even if it might not have your personal redundancy terms, what it will have is grievance process or any internal company processes. So it's a really good place to start when you're looking for what are my rights. And I would say, a huge percentage of my clients have never read or looked at ever their employee handbook. In fact, a lot of them will say, I didn't even know one existed. Where can I get it? So you can ask for it, and these procedures should be sent to you if you're going through any sort of procedure at work.
So it's kind of incumbent on the employer to make sure they're available and make sure that people have access to them. But
absolutely,
also the employee should, I guess, make the effort to ask for them if they haven't been given them already.
Yeah, I think so, particularly with a small employer. Some small employers may not have bothered to do one. So if you're an employee and you're wondering, where do I check my rights, and my contract of employment is very brief, if you've got a company intranet system, a lot of employee handbooks sit on that. If you're more in a services industry, so I've seen this a lot in hotels, for example, employee handbooks are often sitting on someone's desk, and and an employee will ask, where is it? And it will say, well, it was on such and such's desk and it was available for everyone to look at. So just ask, where is it? And obviously for those of us that aren't going into work at the moment, if you are still being subjected to a process, it's, the employer has to give you those processes if they're going to subject you to them. So ask for those.
So when they're looking at the handbook, the things that they're looking for are the processes involved, how the employer will reach a decision, or?
Yeah, it's probably not going to have a detailed, I will sit down with such and such and we'll look at this and this and this. It's not going to have that level of detail in it. But what it will have is your entitlements as to who you can bring with you, the appeal process. Some companies, for example, have a double appeal process, so you can appeal twice. So I've seen that. That's going above and beyond what the law requires you to do. But if your internal company process says that, then, be aware of that and use it. If your company doesn't have a process at all, the minimum they need to do is follow the ACAS code. ACAS is ACAS. It's a conciliation service, but it's also an advisory service. So it is not a replacement for legal advice, but if you're going as an employee or an employer, actually, if you're confused, they have a helpline that you can phone, and they will give you some basics that you should be aware of. They also have written a code, which if you are in breach of that code as an employer and you lose a case, could add up to 25% on top of the award you're already liable for. Okay. So you must follow the code. It's very important. It sets minimum standards that you must adhere to. So perhaps if you're an employer and you've never thought about what does my disciplinary grievance whistleblowing process look like, that's a good place to have a look. They also have a function for if you're just starting a tribunal claim, and maybe this is going a bit beyond your question, but I think it's quite important to highlight. If you have a claim, you have in general a 3-month time limit, and that's quite a tight time limit. COVID-19 is not going to be an excuse to extend your time. Well, you don't know, but probably not. I think one of the views is you were sitting at home, you could have researched the law. So please don't miss your time limit, because you're making your life very difficult for yourself. Even if a company internal process is still running, say you've been dismissed and you think, yeah, but I was appealing and they took 3 months to hear my appeal. Mm-hmm. Don't be late. But you can contact ACAS. They've got an early conciliation scheme. So what that does is it stops the clock. So I shouldn't say it protects your time limit. It does to a certain extent. But if you've got, say, a day left before your 3 months, the moment you've contacted ACAS and said, I am intending to make a claim, it stopped the clock. So you're still on time. Okay. And ACAS's role then is to call the employer and say, this person is potentially bringing a claim. What do you think? Can you offer some money? And the employer might think, yeah, actually, let's talk about it. Or no, I think it's a load of rubbish, whatever they say. But it's paused to give you that chance to talk to each other. And
it's kind of like mediation before it gets to a tribunal stage.
Correct. And it's mandatory to do. So if you think my employer is not going to be interested, you still have to contact ACAS and you still have to talk to them. So, otherwise the tribunal will reject your claims. So go to them first. And then that's their other function. And it's very easy to do. I tell clients to do this themselves. There's no point in paying me to fill out that form. But it's if you type into Google early conciliation ACAS, it'll come up with the individual notification form. It's free of charge. It will ask for your name, your employer's name, and ask you to submit your intention to bring a claim. Once you've done that, there is a more detailed form that you fill out. To be fair, you can get a lawyer to help you with that, But more than likely, ACAS will then give you a ring and say, you've just submitted this, what's going on? You tell them, and they take it from there.
Okay. So I guess just overall, I guess on the furlough side of things aren't quite so set in stone. But
no, because it's new, and I think people are still working it out.
But the redundancy side, everything still runs as it normally would.
Absolutely. Yeah, the redundancy process, I'd say to the employers out there, it is really easy to get redundancy processes wrong. And I've seen very big employers where I've scratched the surface and I've found things that are wrong. So, you know, if you want to get it right, I think, well, get some advice is the best way. But at the very least, you know, contact ACAS for some guidance. At least that's free. And, you know, take care that you're really at all stages keeping an open, objective mind when you're doing this. And the more you do that, the more likely it is that the redundancy will be fair. And make sure that it's a genuine redundancy situation. You know, if it is, fine. But, you know, one of the queries I don't like is someone will call me up, and this does happen. I want to get rid of them. Do you think I can make them redundant? And I'm like, well, you know, let's talk about why you want to get rid of them, and maybe there's another way. Because if you still have a need for that job, then that's not a genuine situation.
Okay, so I guess thinking about what's genuine, what's fair, what's kind of the correct way about approaching a redundancy still applies despite the coronavirus and all the rest of it. And on the
absolutely still applies. Yes.
Yeah. And on the furlough side, just sort of following a similar pattern would be helpful, I guess.
Yeah.
But nothing's quite set in stone.
No, just make it fair.
Yeah, I guess what I'm getting from it, and you can correct me if I'm wrong, is that a large part of it is just decent communication between employer and employee, and sort of taking
absolutely
step by step from there. So
absolutely.
But all of that's really helpful, actually.
Good.
For all the members of the Jamat will find that really helpful. So those are the two avenues, I guess, that are available in the event that a business isn't able to sustain itself through coronavirus.
Yes.
Oh, one thing that I have forgotten to ask, actually, and
this
is because we've seen it as a rumor, and at the moment in the Daily Star and in various other
quality publications.
So the idea that the furlough scheme might reduce to 60%, nothing's been finalised about that yet, has it?
No, we're due a statement from Boris Johnson tomorrow. So any announcements of that nature, we don't know what he's going to say in that statement, but it's rumoured that it will be reduced. And Rishi Sunak earlier this week has reassured people that businesses are not going to be left at cliff edge, which means at the moment, these schemes that are in place expire at the end of June. And so, you know, people are rightfully so wondering, well, at the end of June, what happens? Do I just not have a job anymore? Do I not get paid anymore? You know, businesses are wondering, does my funding stop? Am I going to go bankrupt? So, you know, that's the only reassurance that we've had so far, that they're not going to be left at cliff edge. And then what that means, I think a lot of news media is making a guesstimate as to what that could mean. So, you know, for the self-employed, I think the guess was that it will reduce to people that earn over 30,000 are not going to get it anymore. For the furlough scheme, it was, well, now it's going to be 60% of salary. So I'd imagine that it will be something like that. And I imagine that it will be following the end of June. Because obviously these are very expensive schemes for the government to keep running. It's not going to be sustainable to have those in place forever. But at the moment we don't have the finalised details, and I anticipate that either we'll get that announcement from Boris tomorrow, or he'll tell us to wait for 3 weeks and he'll think about it
and see what happens next. It's
Mm.
difficult, isn't it? Because everything's changing constantly. It's sort of also, I guess, for businesses and employees, just to kind of keep on top of things as you go along. But it can't be easy, I think, in terms of it creating quite a lot of anxiety, etc. But
in lots of different ways. I mean, even down to annual leave. You know, I've had this example as well. Should I force my employee? Well, I had this question from an employee saying I've been forced to take 40% of my annual leave before the end of June. And my gut reaction was, wow, that's unfair. So I read the legislation, and it said if it's not practicable for you to take your leave due to COVID-19, then, you know, that annual leave period, a lot of people would lose it after a year, but it's been extended for 2 years. So, you know, that can be rolled over. So this employee went back to the company and they've said, yeah, we thought about the law and we're still going to require you to take 40% of your annual leave before the end of June. And it's that definition of not reasonably practicable, you know. So what does that mean? Well, and you know, I do things like, well, you go back to the parliamentary debate, or you go back to the policy reason why that was put in place. So that was put in place because what was envisaged is a supermarket worker or an NHS nurse is, you know, if they want to take their holiday now, there's no way, they're too busy. So that's why it was put in place. But the wording actually could support somebody that, well, doesn't want to take their holiday right now because I was due to, well, I wasn't, but I'm making this up. I was due to fly to Mexico and now I can't go, so I want to cancel my leave, you know. But no one's tested that in the courts yet to see what that actually means.
So do you think after the whole coronavirus lockdown is over and hopefully we've got rid of the virus, there will be
Hopefully
a sense of recourse for people who have been unfairly treated during this time?
Well, I hope so. It depends on what the unfair treatment has been. You know, I think most of the queries that come my way around discrimination, and, you know, unfortunately, those queries are still ripe and still busy. And I would have thought that perhaps this period would have helped some people in that position because you're not in the workplace having to deal with that every day. And unfortunately, you know, that's come up in other ways. You know, for example, there was a mother moved to a different role that required her doing video calls all day. But she's a single mum with a young 4-year-old child who, if anyone has a 4-year-old child, I don't know if they're going to behave themselves while mum is on video all the time. Yeah. You know, so I think things are still coming up, and yeah, again, I'll say to any employers out there, you know, just try and be as fair as you can. Yeah, you know, now's not the time if you have an employee that you had it in for to show any of that. We really need to show that solidarity right now. You know, we do within our community, which is beautiful, but let's extend that to the people that we're looking after as our employees, as our workforce. You know, how can we be more caring?
Yeah, no, I think it's sad that those things are still happening even now. Well, let's answer perhaps some questions that have specifically come up from the Jamat.
Okay.
So these are questions that have come up during the Economic Planning Board casework that they've been carrying out. And so they're all anonymized, but let's start with the very first one. So I'm a working parent and struggling to manage looking after my kids at the same time. Can you share any advice on what sort of leave I can take and whether there are any other options to consider as I have a disabled child?
Okay, so there's the right to flexible working, and you know, you have the right to make that request. Your employer cannot discriminate against you for making that request or cannot penalize you in any way for making that request. If they do, then that's called victimization It's, if you raise a complaint and the employer doesn't like it. I had this come up the other day as well. In fact, the employer said, "I'm very angry that you've raised this," and then started treating the employee very badly. So they're not allowed to do that. Unfortunately, I think this is an area of law that needs to be strengthened beyond that, because what they have, the employer then has the duty to consider your request.
Okay.
So they can consider it and they can turn it down.
Okay.
Yeah. But they have to show that they have considered it. So if it is at all feasible or workable for that employer,
Right.
then they should be granting the request. But some employers, will say, well, we considered it and it didn't work. In which case, you do then hold the right to appeal if they turn it down. Mm-hmm. And the appeal will be looked at, unless it's a very small employer, by someone different, fresh pair of eyes, and hopefully, that will go forward. Beyond that, if you think there's any discriminatory reasons for why this has been turned down, so one of the protected grounds is sex on the grounds of maternity, for example, or disability by association, potentially. So you could raise a grievance at work. I mean, I would do the flexible working request first, and then if that doesn't work out, then think about why have they actually turned it down, and potentially then that's somewhere where you could raise a grievance about that.
Okay, great. Okay, so let's do the second one that I have, which is, I'm in my 70s and I'm a cleaner. I have underlying health conditions and I'm worried about going into work. Can I refuse to go in? Hello? Hello? Have we lost each other? Can you hear me? No?
Hi.
Hi.
I think our connection's gone a bit funny. Hopefully they can edit that out. So you're back.
I'm back. Sorry. Okay. So our second question is, I am in my 70s. I'm a cleaner and I have underlying health conditions and I'm worried about going into work. Can I refuse to go in?
I think you can, yes. At the moment, cleaner is not deemed to be an essential worker, and I will say this only applies till tomorrow, because I don't know how Boris is going to change things tomorrow. But assuming that it stays the same, and all the lockdown restrictions aren't lifted, quite so much. At the moment, the orders are to stay at home unless you're a key worker. And a cleaner, as much as my friends and other people have been complaining about not having their cleaners, so I think, yes, you do have the right to refuse. I don't know what the basis of your employment relationship was, though, from that question. So I'm assuming that this lady would have been a self-employed worker that was paid on a week-to-week basis. I would imagine that in this climate, there aren't any cleaners really going in unless they're breaking the rules.
Would that still apply if she was, say, a cleaner for one of the NHS hospitals, etc., or would that be a completely different scenario altogether?
Well, I think if you're an employee, then, I'd be having that discussion with your employer about, can I go on furlough?
Okay. And that is grounds to go on furlough, that if you are concerned for your own welfare,
ask the question. You don't really need necessarily grounds to go on furlough. There's that, it's an agreement, so you can either agree to it or not. And so for those reasons, I think most people would be quite sympathetic to the fact that you are worried. I would hope that anyway. So if you're an employee, I would ask to go on furlough. But in any event, the cleaner is not in the key worker categories. So at the moment, wouldn't be working right now anyway. Unless you're a live-in cleaner, which I don't think so, because she's worried about going to her place of work. You know, the live-in examples are a little bit different.
And are they different in the sense that they're already on site, so it would just continue as is, so there wouldn't really be there wouldn't be a risk as such, because as long as the household's all in lockdown, I suppose.
Correct. So you know, if you'd chosen to be on lockdown with the people that you work for, and I was reading this interesting article about the super rich and, you know, their staff and the drive for recruitment for living staff just before we went on lockdown. So if your staff live with you, obviously, then that's fine because you're locked down together. But, you know, at the moment, we're restricted from visiting anyone else's house or continuing our role unless it's for an essential reason, and cleaning is not essential.
Okay, perfect. So last one, I'm on sick leave, which is due to end soon. Can I ask my manager to furlough me? And is this something I can insist they do because they're doing that with some of their staff?
Again, it's a similar answer to what I had before. If you want to go on furlough, it's got to be an agreement with your employer, you know. So they can either agree it or not agree it. If you're on sick leave, assuming, well, again, it depends on, you know, some people are getting statutory sick pay, which probably isn't as much as your 80% salary, but some people are getting, have employment terms which entitle you to your full salary if you're on sick. So you may want to, depending on who, you know, what circumstances apply to this person, you might want to make a decision on whether it's beneficial to get signed off, you know, for another few weeks, and if that's genuinely something that you can do, or whether you can go back and have the furlough. Assuming you're an SSP, you know, probably you want the furlough instead. But yeah, there will have to be an agreement with your employer. There's no right for you to insist that this happens. I will add this though, if everybody else in your department, say, has been furloughed and you're the only one, and you think that you have a protected characteristic that is making the employer treat you differently, then maybe you have some grounds for unfairness there. So protected characteristics for the benefit of everybody are sex, race, religion, disability, sexual orientation, and age. And sex includes maternity as well.
Okay.
Yeah.
All fascinating. And just one question that arose from the last thing that you said, just for those that don't know, what does SSP stand for?
Oh, sorry, statutory sick pay.
Perfect. And so I guess overall what I'm getting from all of this is, on the redundancy side, everything stays as is. In terms of any anti-discrimination, that also stays as it is. So you have to be as careful as possible to not be discriminatory in any way. And the grounds are the ones that you've just said. So of gender, which includes maternity, age, religion, and what are the ones I'm missing?
Disability, race, and sexual orientation.
Okay, perfect. So if it's any of those are legitimate grounds still for anti-discrimination, etc., and that still continues as is. Indeed. And on the furlough side, although it's less set out by guidelines, your opinion would be to continue, assuming it's laid out, I suppose, in a very similar way to redundancy.
Yeah, I mean, that's the super cautious approach to take. You know, obviously some employers might take a more flexible approach, and, you know, it's yet to be tested by the tribunals. The tribunals at the moment are closed other than for telephone hearings, so nobody has gone to tribunal to test this. But, you know, what I would say, make it look as fair as possible. That seems very common sense. And, you know, in the redundancy process, that is the way that it has been made to look fair. So, you know, which is why I used that analogy. So.
Okay. And I guess finally, just for both employer and employee to have sort of honest and decent conversations, I suppose.
I think that's really important. You know, a lot of the discrimination work that I see could have been avoided if you'd bothered to talk to your employee to make them feel welcome. You know, the BNP Paribas case that I did which I can talk about because it was widely reported and in the public eye. This was a lady that went into work every day, only person in her department that was a woman, and it felt like an old boys network. She used that terminology. And, her boss was more chummy with the man than he was with her. And 6 years of working in an environment like that, where, and worse things happened, but where your confidence is just chipped away day by day. What can we do to make that employee feel like, actually, you're part of this team, you're part of this family, you're being treated the same?
Yeah, I suppose it doesn't take huge amounts. It just takes conversation and discussion on how employees are feeling.
Very much so.
And I suppose as well, from an employee's perspective, trying to be as honest and open about what you want as well.
Yeah.
Probably quite helpful along the way, so that dialogue does take place at some stage.
Yeah. I think the best ways to resolve things are, before the employee even gets to raise a grievance, often they're just raising something with their manager and saying, look, this is bothering me. So if, as the manager, rather than being the person that I spoke to earlier this week, said, well, I raised this with my manager and he told me that he was very upset that I ever raised any sort of concern at all. Don't be that person. Let's work with the employee and be sensitive about it, because if you are, then potentially this employee is not going to be then offended by other things that may come up.
Yeah. And is there a specific way that you might suggest for an employee who does have a grievance to try and avoid a situation where a manager says, I'm really upset? Is there a certain way that they could raise something, or is that just not?
Well, I think, this is a much bigger question on the art of rapport and connection. And obviously within the Ismaili community, we've got NCAB. So, you might have a workplace mediation facility, for example. That may not be where you start if things can be resolved by an informal conversation, but a lot of workplaces have that. NCAB will resolve disputes between Ismailis and non-Ismailis, and we do commercial disputes as well. So you might want to consider that. It's a free service, and we can talk to people, or we can talk to both of you and see if we can resolve anything. And in terms of how to approach difficult conversations, I mean, that's a real art form in itself. And the first step of that art form, to use the words of Tony Robbins, really is connect, understand and appreciate their world. And the rest of his mantra goes body, mind and spirit. And I think there's some real wisdom in that, because with the connection is the art of rapport. Are you using the right body language? Are you going in with, really angry tone? Because if you're angry from the start, when someone's not even heard you, how do you think they're going to respond? So how can you connect to them? How can you understand and appreciate their world? What things drive them? God, they were getting very psychological now, and I'm sorry about that.
Probably slightly beyond our remit, but it's all interesting, and I think quite helpful in the sense that knowing how, I think from an employee perspective, there may be some reluctance to broach certain subjects, etc. So I think, understanding someone's desires, different people work in different ways. So can you connect to that person through their children? Can you connect to that person because they want to make more money or whatever? So, going back to the flexible working example, if your employer is very money driven, how can you, this is really going beyond the remit, but is there a way to sell that request to reassure your employer that, their bottom line isn't going to go down, that you can work smarter from home, or more effectively? So that's what I mean, how can you sell it to them so that it will work? And part of that is presenting solutions as well to the grievance that you're having, and then seeing if it's surmountable.
seeing if that's workable. And you don't have to do that, because I really think this is more the realms of psychology rather than employment law. but you know, these things do work. So, you know, they're all important to think about as well.
No, thank you so much. This has been really helpful and really informative, and really interesting from my perspective as well. So thank you so much.
Well, it's been lovely to talk to you as well, and I hope that it helps some people out there.
Thank you so much.